Already, we have discussed two major fault grounds of divorce under the Dissolution of Muslim Marriage Act 1939. So, the remaining six we will discuss in this video. So, the third one is regarding the sentence, and that is the husband being sentenced to a term of imprisonment for 7 years or more, then the wife is entitled to a decree of divorce. But this can be passed if the sentence has become final. So, unless the sentence is not finally pronounced by a court of law, the decree of divorce would not be allowed under this ground. And the fourth one is regarding the husband's failure to perform matrimonial obligations. So, the husband's failure without reasonable cause to perform matrimonial obligations for a period of 3 years or more, the wife is entitled to obtain a decree for dissolution of her marriage as decided in the case of Manwari by versus Savir in 1971 by the Madhya Pradesh High Court. So, according to Abdul Rahman, an expert on Islamic law, matrimonial obligations constitutes the basic obligations. So, in violation of that, a wife could go for a decree for divorce. And our fifth one is regarding impotency of the husband. So, regarding impotency of the husband was a ground of divorce even before the coming into force of the Dissolution of Muslim Marriage Act 1939. And under the Act, the very burden of proof on the husband that he is free from impotency. So, on the above ground, we would like to discuss an important leading case, and that is of Ghulam Muhammad versus Hasina, and it was a case of 1988 decided by the Jammu Kashmir High Court, which expressed that once the husband get himself medically examined, the court has no jurisdiction to direct him to get examined by another medical board. So, our sixth fault ground for which a wife is entitled to a decree of divorce is insanity, leprosy, veneral diseases. So, insanity, leprosy, and veneral disease under the Act, the requirement is that the husband has been suffering from insanity for a period of 2 years or more. The Act does not spell out whether the provision relates to post-marriage or pre-marriage insanity. Similarly, leprosy is a ground for a decree of divorce. Leprosy is without qualifications. Even the duration of leprosy is not stated. It would therefore appear that it may be of any duration and it may be of any type. The wife can also file a suit for divorce on the ground that the husband is suffering for virulent veneral disease. It would appear that under the Act, the veneral disease need not be in a communicable form, that the only requirement is that the disease should be in a virulent form. Even if the disease has been contacted from the wife will be entitled to a divorce. And our seventh ground, that is repudiation by wife. So, repudiation of marriage by the wife is another fault ground for which the wife is entitled to file a suit for divorce. The wife is entitled to file a suit for dissolution of marriage on the ground that she was given in marriage by her father or grandfather or any other guardian before she attained the age of 15, that the marriage has not been consummated and that she had repudiated the marriage before she attained the age of 18. So, the last valid fault ground for a wife to file a suit for divorce is cruelty of husband. So, cruelty of the husband, under the Act, wife is entitled to a decree of divorce if her husband treats her with cruelty, as habitually assaults her or makes her life miserably. Cruelty of conduct, even if such conduct does not amount to physical ill treatment, it includes all cases of physical and mental cruelty. When the husband associates with women of evil repute or leads an infamous life, means with prostitutes, but one or two lapses from virtue will not be enough. So, the husband attempts to force her to lead an immoral life is considered to be ground for matrimonial relief, and this has been considered to constitute cruelty. The husband disposes of her property or prevents her from exercising her legal rights over it, which hurts the very sentiment of the wife or causes emotional or mental strain on her, will fool and it will lead to uncruelty. The husband obstructs her in the observance of her religious profession or practice, also falls under cruelty. The husband who has more wives than one does not treat her equitably in accordance with the injunctions of the Quran would also be considered as mental cruelty. So, all these activities of a husband regarding his wife, both physically or mentally, would fall under cruelty. So, this is the eighth fault ground of divorce for which the wife is entitled to file a suit on the ground of either physical or mental cruelty against the husband for a divorce under the dissolution of Muslim Marriage Act 1939. So, in our next video, we would like to discuss the breakdown grounds of divorce, as these breakdown grounds of divorce were discovered by judicial interpretation or by the interpretation of courts. These two grounds of breakdown grounds theory developed. So, in our next video, we would like to discuss these two breakdown grounds of divorce. One is non-payment of maintenance on account of the very conduct of the wife, and the second one, the total irreconcilability between the spouses on different grounds.